So bylaw 15, we're not going to go through in its entirety, but kind of want to hit the highlights for you, the more common questions that we get. So what's coming up? Yes. Hopefully everyone's tracking on the fact that renewals, non-renewals are due July 1st. That is, I believe, a week from today. I don't see any surprise on anyone's faces, so that's very good. But if you have not done your renewals or non-renewals yet, make sure you have those sent out no later than July 1. That notification does have to come from the institution's regular financial aid authority, not from your athletic department. If you have an individual who you decide to non-renew, maybe there was a violation of team rules, or that individual didn't meet a particular academic standard that you were hoping to have them meet during the past academic year, and you non-renew or reduce, it is permissible to reconsider that non-renewal prior to the period of the award, or prior to the next academic year. So even if you non-renew somebody tomorrow, if August 1 rolls around and you have limits left in your team equivalency and you feel like this individual has now earned the right to their athletic aid again, you can reconsider that non-renewal. Any questions on renewals, non-renewals? Okay. Glad to know everyone's tracking on July 7th. So period of the award, we get a lot of questions about this. So the period of the award starts when one of two things happens. Either the student athlete receives a benefit from their scholarship, so maybe it's they went and picked up their books, or they got a room and board check, or they participate in practice. Whichever occurs earliest is we'll consider to be the start of the period of award for that respective student. And then obviously the ending is a little bit easier to figure out. It ends when the financial aid agreement says it concludes. So if you're doing term by term and you're only awarding somebody aid for the fall semester, the period of the award obviously ends at the end of the fall semester. If it's for the entire academic year, it ends at the end of the spring semester. Pretty easy, right? Okay. So if you are providing athletics aid, you cannot provide it in excess of an academic year. We do define that, again, opening day of fall classes through spring commencement. So summer is different. We'll get to that in a second. And it is permissible, again, to break up the academic year. So how many people, just quick show of hands, do term by term awards instead of full academic year? No? Nobody? Certainly less work on your end, so that's smart. I wouldn't want to do this process twice a year, but certainly Division II institutions have every right to do so, should they wish. So summer aid, as I mentioned, is an additional award. So in that initial financial aid agreement that's covering, it sounds like for all of you, the fall and spring semesters, you do not get to include summer term as part of that. The nice thing about summer aid, should you choose to award it, is you do not have to issue the same written statement you issue for the academic year award. Why is that? Simple matter of timing, right? Maybe you have a student who's going to enroll in a summer school class and you don't know that until a day ahead of time. Good luck running around campus and getting all those signatures that you need. So as long as you're communicating to the student the aid that he or she is going to receive for the summer term, it doesn't have to be that written statement. It is also permissible to provide summer financial aid prior to initial full-time enrollment. So you've got somebody who's really eager to show up and wants to knock out a couple classes in the summer prior to full-time enrollment. By all means, that individual can do that. The one caveat there is for your 2-4 transfers. Again, if you give them aid in the summer prior to, they better be meeting all 2-4 transfer requirements, or else they're sitting for that year. They've triggered transfer by receiving aid at your institution. Any questions on that caveat? Okay. So increases, reductions, and cancellations. We get questions about this pretty frequently. You can increase an award once you've given it at any time prior to the period of the award for any reason. So again, you're sending out your renewals by July 1. Coach looks at his equivalency limits and says, you know what? Sally was an all-conference performer last year on our volleyball team. She now holds every record at her position. I gotta give her more aid. As long as volleyball practice hasn't started yet or Susie hasn't received any benefits, by all means increase her aid for an athletics reason. Once the period of the award starts, it has to be a reason unrelated to athletics. So maybe Sally has some demonstrated financial need that her federal aid isn't covering. Or there's a change in status in the beginning of, or during the term, father loses his job and can no longer provide the expected family contribution they were hoping to pay. Things like that. Yeah.
I have a question about what is considered an increase. For example, if a student receives a grant and aid letter and the student's getting $4,000, $2,000 for fall, $2,000 for spring, something happens, coach finds out the student's going to graduate in December, season already started, and the coach says, well, I'll give you all $4,000 in the fall semester. Is that an increase? Because now that one semester the student's getting more than he or she would have had in that fall semester to begin with?
Yeah, so the question was what actually constitutes an increase. So if you have a financial aid agreement, it's supposed to be for the full academic year, your letter that the student, or the financial aid agreement that the student signed says it's going to be $2,000 in the fall, $2,000 in the spring. If you've specifically specified that, then getting $4,000 in the fall is an increase. If you haven't specified, we wouldn't say that it necessarily is. It just depends how you've worded that.
So if you said $1,000 this year, that's not fine.
Right.
We say fall, term, spring, term.
Yeah. Yep. So again, unrelated to athletics reasons, we get questions of coach has 0.3 left on his equivalency. He's got 3 seniors and wants to increase all 3 of them by 0.1. People feel good about that or people feel bad about that? You don't really know what to feel about that. Potentially that's fine. If it truly is, this senior class is doing all the things right, by all means. If it's a golf team and your 3 seniors are the only ones who can do anything related to shooting under par and your freshmen are terrible and you start to realize this is really athletically related, you're going to want to ask those questions, okay? But on the face, if they're providing it across the board to a particular group of individuals for a non-athletics reason, we wouldn't say we have a problem with that, unless, again, there's something glaringly obvious about why that particular group is being targeted. Okay? So in terms of an initial award, student athletes who are not receiving athletics aid from the start, so they come to your institution, they're just receiving institutional aid, they haven't triggered counter status, they're just receiving a few academic scholarships, and then coach says, Frank's been doing a really good job for us, I've got some money left, let's put him on scholarship. He's not starting for us by any means, but he's really contributing in practice and is a good team player. In that case, you are able to provide that initial award at any point. So even though, again, the period of the award has really started for the rest of your student athletes on scholarship and it feels like you're increasing, well, you are. If you're going from 0 to something, you're inherently increasing. But again, since it's an initial award, we can all feel pretty good about that because it's potentially rewarding someone for good behavior. Yeah.
And it's an initial award for that academic year. So say freshman year they had $1,000 or got canceled. It was also where anything. In the spring they saw and coach says basically the same scenario. So they can use it at that point or they can roll it after the career.
Yeah, this is initial in the entire career. So this student has never been on athletics aid. Again, truly meant to be a, hey, doing all the right things. We've got some money left in the budget. We want to give you aid for this first time. Then moving forward, you need to continue to adhere to the respective financial aid requirements. What that really does is circumvent or doesn't allow people to use that as a loophole. Because otherwise you would have individuals that would just non-renew essentially do a tryout maybe in the fall, and midway through the fall semester you've said, yeah, okay, you're good enough for 8 again, and throw 8 at them. It's exactly what we don't want to do. So yeah, just that truly initial first time award. Great question. Any other questions on that one? Okay. And then again on that last bullet, if you do provide an initial award, let's say October 15th, just to pick an arbitrary date, and you give Frank that aid, you cannot make that retroactive to the beginning of the term. So you can only provide Frank aid from October 15 through the end of, if it's term by term, end of fall semester, or end of spring semester if you're doing the full academic year award. Okay? So you cannot increase, decrease, or cancel during the period of the award based on a student athlete's athletic performance, good, bad, or otherwise, on the basis of a medical injury, illness, whatever that may be. Quite frankly, your legal counsel would probably have more to say about that second bullet than NCAA legislation would, but that's there again as a safeguard. And then for any other athletics reason. So again, really protecting the student in this case to ensure that this isn't a situation where a coach thought they were making a really good decision by offering this individual aid. Frank ended up not being as good as anyone thought Frank was going to be, and pulling the rug out from underneath Frank, and Frank now has no way to pay for college. That all makes good sense, right? So, as it relates to decreases, again, coach is really excited. He thought Frank did awesome this year, his first team, all conference, decides, you know, he was only getting $1,000 last year. Next year we're going to give him 10. So by July 1, you've sent out your letter. Dear Frank, congratulations. Here's your $10,000 scholarship for the 14 academic year. Frank signs that. He's excited. Mom and dad are even more excited. That's less they have to pay. He returns it to your institution. Then all of a sudden, Frank breaks his ankle or does some other thing that suggests to coach, maybe playing in a summer tournament, that, ooh, that was a one-time thing for Frank. He's really not as good as anyone thought he was. And I'm starting to rethink giving Frank that $10,000. Sorry, coach. You've made that decision. You get to live with it. Okay? So you cannot decrease once the student athlete signs that financial aid, even if the period of the award hasn't started. So for your students who are really tracking on it and signing those financial aid agreements right away, make sure you're not taking their aid away. Okay?
Is DQAMA looking at tracking on the issue that Division I is about 4-year offers now?
Yeah. So the question was, are we looking at similar how Division I, what Division I did several years back of allowing 4-year scholarships? We have not heard that specifically. We'll get into a little bit at the end. The legislation committee is doing a review of bylaw 15 in its entirety of what should be changed, not changed, easier to understand. But I have not heard really a clamoring for that. Kathy, I don't mean to pick on you, but have you heard anything from the management council perspective about 4-year? Yeah, I don't.
There's just a lot of good PR came out of Division I yesterday. Several schools, particularly Southern Cal.
Yep.
Announced they were still going to start getting.
Yes, and I don't think the timing is coincidental given what else is going on in California this week and the previous 2 weeks. But yeah, that's certainly something that will be included as a topic of discussion in the overall review, but we have not heard great momentum for it. Good question. Okay, so what if your student athlete really did something wrong and you want to get rid of their aid? So they got arrested, they violated some team rule that's very clearly laid out, flat out lied on an admissions application about not being a felon. You laugh, it's happened. So if a student triggers any one of these 4, it is permissible at that point for your institution to reduce or cancel the aid. So probably the most common is the 4th bullet point, so voluntarily withdrawing from a sport. The key there, though, is that you still, even if a student athlete voluntarily withdraws from a team and you're canceling or reducing the aid, the next step, as you all know, is that you have to provide notice to the student of that action and provide the opportunity to appeal. People say, the kid voluntarily withdrew. Why do I have to go through the whole pomp and circumstance of offering them an appeal? It was Susie's choice. Well, the appeal is where you really figure out, was it truly Susie's choice, right? So was it truly voluntary, or were there some other forces that led Susie to voluntarily withdraw from the team? So make sure, even in those instances, you're still providing that opportunity to appeal. The other 3, renders himself or herself ineligible for competition. So if you're not meeting progress toward degree requirements, your aid could permissibly be reduced or canceled. Fraudulently misrepresents himself or herself. Again, the felon thing was kind of extreme, but we've seen that. If they just truly fail to show up on campus at all, and then stroll in on September 15th, classes started 3 weeks ago, you're not holding up your end of the bargain, makes sense. And then serious misconduct. So if you have a student who goes through your institution's respective process, maybe was accused of theft, sexual assault, whatever it may be, and your institution determines that that individual was ultimately responsible for that act of serious misconduct, it is okay then for you to reduce or cancel that aid. Obviously, at that point, the student has done something non-athletically related to jeopardize their eligibility for aid.
If you have, say you have a $4,000 and your institution dispersed a 2012, 2000 in the spring, and then if the kid voluntarily withdraws from the team in November, would we allow them to keep their aid through that fall term? Would we have to still provide the appeal process because we have to disperse the aid for the spring?
Yeah.
Technically satisfy the contract in that we allow them to keep this 2002 fall.
Yeah, so the question was, if you have a student who midway through the fall term says, I'm voluntarily withdrawing, your financial aid agreement says you're going to distribute the $4,000 in equal amounts over the 2 terms, so $2,000 in the fall, $2,000 in the spring. But again, voluntarily withdrawing in the middle of the fall term, the institution says you can keep the $2,000. We're not worried about reducing for this term, but for the spring, you don't get to keep hanging out on our dime. Still a cancellation at that point because you have not provided them the spring aid that was otherwise promised to that individual, and they would still have the right to a hearing.
But the first 3 conditions do not need to have a hearing?
No, they still would.
They all get
Yeah, anytime you reduce or cancel, you always have to offer a hearing. But we get a lot of questions of why on earth do you need to provide a hearing if the student athlete voluntarily took an action. And again, it's because it's not always voluntary. Yeah. It's you are encouraged to seek other opportunities. Yeah. So it's important, honestly, we would advise an annual basis that you're working with your institution's general counsel of the fine print that I'm sure you all have on the back of your financial aid agreements. So that this particular piece of legislation is on there. Any additional non-athletically related conditions that you want to put on the scholarship, you can do that. Again, there cannot be an athletics nexus, but if you have an additional institutional policy that you want to include as a condition of your financial aid agreement, by all means, you are able to do that. But making sure that you're looping in your general counsel because it is a contract. I mean, you're offering, students accepting. I do not have my JD, but I know that much about our contract. So making sure that you are truly providing a document that's been thoroughly vetted, so you don't have an issue should it escalate when you have a non-renewal or cancellation.
Karen, I'd like to know in the room, as far as those appeals with student athletes who voluntarily quit, have any of you faced that? I've been doing this a long time and I've never had anybody contest that. I would just wonder if anybody else has. I see hands. Okay.
Yeah.
I would just wonder, their argument would be that I was coerced. I mean, that's what you're saying, that there may be something hidden there that we don't see, and until you put them in that hearing or an opportunity to do that,
Right.
you might find that out.
Yeah, and hopefully it's rare, right? I mean, you're going to hope that your coaches are doing the right thing and that they're not running kids off. But people often assume that, and by offering the appeal, as you all know, that doesn't mean the student athlete has to take advantage of it. But people just think, well, the student athlete voluntarily withdrew, so I don't even need to send them the information on the appeal. That just needs to be standard practice for any cancellation, reduction, or non-renewal.
A number of them with the transfer issue, you know, the not releasing the one-time transfer.
Yeah.
But I've never had to deal with it.
Yeah.
We have our student athletes sign what we call a voluntary quit form.
Okay.
When they sign or when they quit, by hearing what you're saying, that wouldn't do it. You still need to send the appeal out. It says they voluntarily agree to give up any awards and benefits.
Yeah, so this particular institution, and I think it's fairly common, we had one when I was on campus, of when a student is withdrawing from the team, signing off on basically saying, I'm doing this on my own accord, I'm giving up my aid, everybody feels good about this. You would still need to have the hearing. That's a pretty good piece of evidence on the institution side when you're having that hearing. To say, you know, if you really truly had an issue, student athlete, why'd you sign this piece of paper? That would have been the time to air the grievances, as opposed to letting it get this far. Good question. Anything else? Okay. So, backing up. So on voluntary withdrawals, if you have a student athlete who withdraws during a term, so keep talking about maybe an October 15th withdrawal, and your institution cancels the aid immediately, student doesn't appeal, so that money goes unused for the term. Let's say maybe the student was getting their aid distributed in room and board checks, and so the November and December room and board checks weren't picked up, so they left $1,000 on the table. It's not permissible to award that $1,000 to another student athlete during that term. However, the $2,000 that they left behind for the spring semester, by all means, you can re-award that. Again, just an additional safeguard to ensure that these student athletes truly, really are voluntarily withdrawing, and not because Johnny is performing better than Frank and coach really wants to give a few more dollars to Johnny this semester, and he's figured out that Johnny has enough financial need that he can slide one past you in the compliance office as a non-athletics reason. Make sense?
We know how to sign their extra before they need campus. The final grades are in there.
Okay.
Based on number one, if the final grades are in there ineligible, are we still stuck to that agreement if they use the summer term to become eligible?
Okay, so the question was, if this institution's on top of it, has already done its renewals.
Based on grades.
Yeah, so, but before spring grades come in, you've renewed. Spring grades come in, let's just say student didn't pass 6. Or, well, you're saying that, but they're getting healthy again. Okay, so yeah, they managed to fix their problem during the summer. If you cancel, you would be able to cancel at that point that they rendered themselves ineligible for competition. But I think best practice, you would need to wait until you truly know they've rendered themselves ineligible, because in that situation, if you were to renew that or non-renew them, or excuse me, cancel more accurately, on June 1 when the grades come out, but then August 1, student athlete is eligible now for competition, you're not technically meeting that at the end of the day. because the student athlete hasn't rendered themselves ineligible for competition or missed the opportunity to compete because it's been over the summer.
Let's even move to the bottom point for the next one. So if they didn't make themselves ineligible for that particular term, they did not award that out to another athlete.
Yeah, so that piece only applies to voluntary withdrawals. Yeah, great point. So the inability to reaward during the term is specific to the voluntary withdrawal. Again, a safeguard for the student athlete whose aid is being reduced or canceled. Now, if you have a student athlete who triggers any one of the first three, one would argue that individual doesn't deserve much protection, and therefore, by all means, you could reaward aid during the term. Because if anything, the student athlete has put you and your coaching staff in a bad spot by leaving them high and dry, potentially even mid-season. Okay? We've already covered that. Again, the non-athletics conditions, so it is permissible to include non-athletics conditions in your aid agreement. So maybe you're going to say you're required to attend 10 hours a week of study hall. Student athlete fails to meet that requirement, as long as it's in your aid agreement and it was included when the student signed it, it would be permissible to reduce or cancel based on that non-athletic condition. Okay? But if they failed to run a 4.540, that does not count. Okay, so hearing opportunity, we've hit this one pretty hard, but just to bring it all together, you have to provide them a hearing opportunity. It has to come from the regular institutional authority, so you don't get to have essentially a different process for your student athletes than you do for your non-student athletes. Makes sense, so you want it to be consistent there. It's important to note that you have to provide that, again, in writing within 14 consecutive calendar days of the cancellation. So you can't just forget to mail them that letter. Those of you that work in the bursar or financial aid office probably can tell many a story of student athletes, not even student athletes, students in general who pay zero attention to their account until mom and dad calls and says, what the heck is this bill that just got sent to me? So you need to make sure you're providing them timely notification of that reduction or cancellation. You have to include a copy of the institution's appeal procedures. So the student athlete has to know what the process is and what they'd be getting themselves into by choosing to appeal. And once the student athlete notifies you that they are interested in an appeal, you have 30 days to conduct that hearing and provide a written response. It's an institutional violation if you choose to but if you do not conduct the hearing within 30 days of receiving the request. Any questions on that? Yes?
For the written component, does it matter what form it's in? Does it have to be handwritten, like a mail letter, or can it be email?
Yeah, so the question was what constitutes written communication for purposes of notifying for the appeal. If your institution recognizes email as an official mode of communication, you could email it to the student. Otherwise, it would need to be sent through snail mail. But whatever your institution recognizes as an appropriate form of communication, which I'm guessing in this day and age for all of you, email would be included in that, by all means, email is fine. Particularly when you're worried about current addresses and things on file, that can get tricky. Any other questions on the appeal hearings? Okay. One of those things that you need to know but hope you don't ever have to use, to be sure. Unlike calculating equivalencies, which we know gives lots of you headaches on a frequent basis. So let's talk about this for a little bit. You have an individual on your roster. The first piece you need to know is that individual even a counter? So this is going to seem very basic to some of you, but this is a step that seems to get skipped by a lot of our institutions. We get a lot of questions on this, so apologize if this seems a little basic. In order to be considered a counter, one of two things has to happen. One, either you're receiving athletics aid, that's easy, right? Or you're receiving any institutional aid that you are not able to certify was granted without any regard to the student's athletic ability. Okay? So the athletics aid piece is pretty easy. And the other piece can be too. I know that tends to panic people. What does that mean? Certify that it's unrelated to athletics ability. You need to be looking at maybe the scholarship application. What does it ask? Does it ask for extracurriculars? Does it ask for leadership? Was the student's athletics involvement at all a consideration for this? Or was it just because the individual is from a certain county or is of a certain ethnic background, triggers that have nothing to do with a student's athletic ability? Okay? So if you don't have either one of those triggers, from a team equivalency perspective, you're not worried about that student. Okay? But we get lots of people who skip further down the line and are calculating equivalencies for students who haven't even triggered counter status. And they're giving themselves headaches because one, that's more math than they need to be doing. And two, they're concerned that they're getting too close or potentially maybe even over the team equivalency limits. Now, for your individuals that are not counters, you still have to make sure that they're not receiving more than the individual permissible aid limit for themselves, but you're not as worried about them from a team equivalency limit perspective. Does that make sense? Okay, so once a student athlete becomes a counter in a given academic year, any countable aid has to be included in that student's calculation. So typically what we'll see is maybe a student who comes in is receiving a bunch of institutional aid. We're able to certify that it was all granted without any sort of consideration of athletics. And then coach says halfway through the year, you know, this kid's doing a really great job for us. Let's put him on book scholarship. So really nothing in terms of overall equivalency limit, just a little blip on the radar. Then all of the individual's other countable aid has to be considered because they've triggered counter status. So that's where it's really important to make sure that you're communicating with your coaching staff before they decide to open their mouth to the kid who's doing things the right way, to say we want to give you books, to make sure that they really truly understand the potential repercussions of that. Because an $400 book scholarship for one semester could very quickly eat away at the team equivalencies depending on what the other aid that student was receiving. Okay? So, what has to be counted? If you've identified that the student is in fact a counter, what all do you have to include? So again, like most good things, we say all institutional aid has to be counted except the following. Academic awards. How many of you were tracking on the academic award proposal from convention? Okay, no one. That's a little bit scary, but that's good because nothing changed because it got referred back. So we are still status quo on academic awards in terms of those requirements. So right now there's two ways a student athlete could have an academic award exempted. It can either be exempted based on their academic record coming in out of high school and meeting certain parameters there, or it can be based off of earning a 3.3 GPA after at least 1 year at your institution. So there's two ways a student could permissibly have an academic award exempted. Legitimate loans. The East Region Compliance Seminar, somebody asked what's an illegitimate loan. Thought that was a fair question. We want to make sure that it is truly a normal loan through either filling out a FAFSA, or maybe your institution has a particular loan process, institutional loan, or another entity that it is actually a legitimate loan that anyone would qualify for based on an established set of criteria, and it's not just because your quarterback is $4,000 short of paying his bill and magically this loan appears for this person. Again, making sure everything's on the up and up. Out-of-state tuition waivers that don't have any relationship to athletics ability. So we're seeing these more and more commonly where an institution wants to make sure, or wants to be able to say, in this highly competitive world, that maybe out-of-state tuition at the end of the day, full cost of attendance is $40,000. But what we really want to do to make this all seem more reasonable to you, to mom and dad who are paying the bills, is say, well, yeah, but we're also going to give every out-of-state student a $5,000 tuition waiver. Again, as long as that's truly institutional policy for all students meeting a set of criteria that has nothing to do with athletics, that can be exempted. Employee-dependent tuition benefits. So if mom works at your institution and junior is going to come, and because of mom's employment, she gets free tuition for any dependents, that does not have to count. Postgraduate scholarships and government grants are another example, or other two examples of things that you would not need to count. Again, these are educationally based. They're not based on athletics performance. They are meant to assist for payment in college and should not necessarily have to be counted. I'm getting ahead of myself. So there's your criteria for your high school academic awards. You would have to meet one of three. So either you're in the upper 20% of your high school graduating class, you have a high school cumulative GPA of a 3.5, or you have 100-some ACT, so all 4 sections combined, just like we do for initial eligibility, or the 1140 SAT. Again, key there is or, so you don't have to meet all 3 of those in order to exempt an academic award. We do sometimes get questions of, what if the kid went to a high school that graded on a 5-point scale? That's where those of you that are in admissions can be of a great help to financial aid, because I believe most most admissions offices will recalculate the GPA for all incoming students to ensure that you're assessing on an equal playing field. So if you're having trouble determining if the student does in fact have a 3.5, maybe it's a weird grading scale or whatever the case may be, reach out to your admissions folks. What's interesting about this, and what the proposal was wanting to change that was ultimately referred back, is that if you have a student who comes in the door and is meeting one of these 3 requirements and qualifies to receive an academic award, that individual doesn't necessarily have to be an all-star student on your campus for the rest of their career in order to have that aid exempted. So as long as they're meeting whatever the minimum is to have that award renewed each year, you're continuing to exempt the award based on the high school record, which sometimes feels a little uncomfortable. I don't know that everyone's doing that across the board, because a lot of it, again, is going to be based on the criteria necessary to continue to earn that award. So hopefully you don't have an academic award that the renewal standard is a 2.0, but conceivably that could be happening, that you have a student who's not so great while they're there, but came in under the high school criteria. The other option, as I mentioned, is if you have a student who maybe didn't meet one of those criteria coming out of high school, but has done really well at your institution and has that 3.3 GPA, that academic award can be exempted for that individual.
Just for clarification, then, if a student comes in who is a freshman, who is in the upper 25%, has a 3.0 and 1,000 on SAT, even though there's no athletic component at all to that scholarship, it is considered countable aid.
Well, potentially. It depends what because if you certify that it has nothing to do with athletics,
Right.
and that's the only aid that they're receiving, because that's where the rub is. If you've got a student who's coming in on an athletic scholarship and is getting an academic award, but you can't exempt it under this, then you do have to count that, because you can't exempt it as an academic award.
So if the student's getting an athletic scholarship and gets an academic non-athletically related, doesn't meet this criteria, it does count towards their counter.
Yeah.
Unless the second year they do better, then we
Right.
can remove
And then you do the GPA check.
But if that student did not have an athletic grant aid, has an academic scholarship, doesn't meet the conditions, it doesn't make them a calendar.
Right, as long as you can, to your point, certify
Right.
that it doesn't have an athletics nexus.
Okay.
Yeah.
So, same situation, they don't meet, but in the second year, you check them, and they're meeting that GPA requirement. You have to check them every year after that then? Once you don't have to?
Yeah, so the question was with the 3.3 GPA, if you're using this to exempt an academic award, is that a one-time check or do you have to check that every year? You would have to check that every year. We wouldn't require a term-by-term check unless, again, that's your institutional policy on the award. But you would have to verify each year that you're meeting that 3.3.
But if they're meeting with the high school criteria, then you don't have that.
Right. So the clarification was if they're meeting on the high school criteria, you don't have to continue to check. And the answer to that is correct. That's exactly why ARC put forward that proposal, because that feels, I saw some of you squirm, that it feels like that shouldn't be the case. Why is your high school record then determining what you can receive as a senior at your institution? Again, hopefully your institutional policy on the criteria for the award is tripping up the student. So if they really truly are a 2.0 GPA student, hopefully something you're considering an academic award doesn't have a renewal GPA of a 2.0, but that's completely institution discretion.
Can I ask one more question? And this is actually for the group PSAC schools. Our Board of Governors waiver is not allowed to be awarded in any way related to athletic ability, but that can be a fairly high tuition scholarship. So if a student doesn't meet but it's not money held at the institution, it's a waiver of tuition. Does that count if the student doesn't meet these criteria as a counter for students receiving athletic aid?
Is it there for in-state students?
Yes.
So the tuition waiver legislation right now is exclusive to out-of-state students. That is something that the legislation committee is reviewing in the overall financial aid review. But if it's a true tuition waiver for an in-state student, that would need to be counted, again, unless you can certify that it's without regard to athletic ability for those students.
Even if the student doesn't meet the minimum criteria?
Well, I think it's two different pieces. So are you considering, this is solely for academic awards. But if it's general institutional aid that you're certifying was granted without regard, then that's not going to trigger their counter status. So government grants, if it's truly demonstrated on financial need, we don't obviously want to penalize those students, even if ultimately it is your institution who's responsible for determining the recipient. So that's pretty common, I think, particularly with state grants. They give you this pool of money and say, go forth with that. And that's true, again, whether you're responsible for selection of the recipient, determining the amount of aid, or if you're even providing supplementary funds. So we had a situation in another state, it wasn't Pennsylvania this year, where they wanted to use the supplemental fund piece here. They wanted to enhance what was already being provided, and that's permissible as well. And then government grants awarded for educational purposes. So frequently we'll see states who have they call them all differently. So I don't know if anyone has a great example of a educational grant the state of Pennsylvania offers. But if it is truly, here's what this state of Pennsylvania is doing to help the children of Pennsylvania move on to their degrees, and it's truly just an educational nexus to that can be exempted from having to count. Does any of our financial aid people have a name they can throw out there of what that might be in Pennsylvania? It's what? FIA. FIA. Does that make sense to everybody else? It's French to me, but it might make sense to you.
What's the other one, Patty, for kids who are in foster care? Chafee.
Okay. Yeah. So there's lots of examples, and each state, again, has their own acronyms and all of that. I know NCAA acronyms can be hard to keep track of sometimes, government can be just as bad in that sense. So just making sure you're aware of what Pennsylvania offers for that, because if it is truly an educational nexus, it would not need to be counted toward the team equivalency. Outside aid, this was deregulated a few years back. So for those of you that have been out this for a while, you may recall at one point there was outside aid with athletics as a major criteria, so like your high school booster club awards, things like that. And then outside aid with limited or no, I can't remember exactly, but limited or no athletics criterion. So maybe it was the Kiwanis scholarship that looked for a whole host of things. Leadership was on the application and the student noted that they were captain of the football team. So there was a slight athletics consideration, but wasn't the whole thing. So several years back, this was deregulated to have two pieces. One, if it's outside aid that has no relationship to athletics ability, so maybe they got a $500 scholarship from their high school for being valedictorian, by all means the student can accept that. For those scholarships that do have an athletics nexus, you want to look at the established and continuing program. So there's three triggers there. One, it does have to be exactly what the title said, established and continuing, so it can't just be a one-off to give the local quarterback some money to pay for college. It truly needs to be an established program. Now, we do get questions from time to time that there's a group in the community that has never offered a scholarship, are looking to do something now on an annual basis to a local high school student, but this is its first year, so we don't meet the established and continuing program piece of this. That's where you just need to be able to get some documentation from that particular group of their intent to continue to sponsor that award. So maybe there's some sort of master plan with that. This is how we're going to solicit funds. This is going to be our criteria moving forward. Whatever the case may be, we certainly don't want to put the student at a disadvantage from being the first recipient of the award if the group really truly does have an intention to continue that program moving forward. The next two pieces really relate to your institution. So the awarding agency cannot restrict the recipient's choice of institution. And by that, we don't only just mean that they can't say, this is only if you go to East Stroudsburg. We also mean you can't say any school in Pennsylvania. It truly has to be regardless of where that individual chooses to attend college in the United States, that individual is going to get that award. And the third piece being there can't be a direct connection between the donor and your institution, which ultimately makes sense, right? You're going to say that if the organizer is your top booster, that starts to feel a little uncomfortable that Susie showed up to your institution and Susie also magically got this $5,000 scholarship from this organization. So you want to make sure that they really are truly separate and distinct. Any questions on outside aid? Okay. Employment. So we do get questions on employment pretty regularly. If it is truly employment and the individual is meeting the restrictions in bylaw 12.4, so they're getting paid for work actually performed, so it's a real job, not a sham job. Their rate of pay is commensurate with the going rate for other individuals performing that same job function, and the employer is not using the student athlete's athletic reputation in any way for the employer's benefit. Any employment earnings would not have to be counted toward individual or team limits. So by all means, if a student athlete wants to go have a job and you as a compliance officer feel comfortable that everything's on the up and up with this job, let them work. They'll quickly realize they probably don't want to work, but let them work. In addition to that, it is permissible for student athletes to conduct FIFRA lessons. So obviously, you all are very integrated with your respective communities. If there is a family down the street, little kid plays tennis, who in your community is going to be some of the best resources to teach the kid tennis? It's going to be your student athletes, right? So again, as long as you're meeting the same similar requirements of going rate and all of that, it is permissible for your student athletes to engage in fee for lessons. That was actually an interpretation that was always on the system. You will see that in the actual manual for the 14-15 publication. So it'll be there in very clear print for everyone to see if you have questions on fee for lessons. Okay, so any questions on that before we see who is really paying attention to me in the last 20 minutes? Okay, so 2 quick case studies. We've got Susie, my soccer student athlete, and she is receiving a total of, looks like $15,000 this year. She's gonna get an academic award. She's in her 2nd year. She's doing really well for you guys. She's got a 3.75 GPA. She's getting her employee dependent tuition benefit. Mom works in the registrar's office, and so Susie gets $6,000 off her bill. Pretty good benefit. And then, but Susie's mom isn't making a whole heck of a lot, and so Susie also qualifies for a government grant based on mom's income. The state's full grant and aid is valued at $20,000 for the 14-15 academic year. So you're working on your financial aid form and looking at Susie. Again, $15,000, I think. Yeah, $15,000 in aid, $20,000 full grant and aid. What's Susie's equivalency? I see lots of zeros, and that makes me very happy. Yes, she's receiving all exempted institutional aid. So you're not even worried about Susie. You do have to make sure she's not ultimately going over that $20,000, right? Because you've got to make sure as an individual, she's not exceeding the maximum. But in terms of how she's going to count towards the soccer team and the soccer team's equivalency limit, coach is not worried about Susie. So he's very happy with you for finding a way to get Susie for free. Okay, so now we've got Bill. He's a tennis student athlete. He's receiving an institutional scholarship, $8,000. A local booster club, $2,000. You've checked that out, and you know that's all on the up and up in terms of no restriction on the donor. And he's also receiving $5,000 from the GI Bill. Again, he's at State U as well, so we're still looking at $20,000 in terms of the full grant and aid. What's Bill's equivalency? What information do you need to know about Bill? Yeah, so remember, you've got that $8,000 in the institutional scholarship. What is that? That could mean any number of things, right? So let's say, or right there, what was that institutional aid, that $8,000, was that certified as not being related to athletics ability in any way? Because again, he's not an he didn't receive athletics aid, so he hasn't triggered counter status by doing that. But we need to make sure that none of his other institutional aid has triggered counter status. So if we certified that as not being in any way related to athletics aid, what's Bill's equivalency? Beautiful, 0. If it wasn't, I'll do the math for you. 0.4. So you've got the 8,000 over the 2,000. Make sense? Over the 20,000, excuse me. I can read. Yes.
So when you're saying certified, not certified, if the specific scholarship that say through an institution or foundation or something, it has leadership or character or something as part of the criteria, we have to go back to the selection committee to see if the student athlete, being a student athlete or being a captain, played any part in their selection
Yes.
of that specific stuff.
Yeah, so the question was when you're asking the question of certified or not certified, do you essentially have to go back to, in some cases, an awarding committee and ask the question, was athletics certified, or was athletics involved in your decision-making process, or would this student have received this award even if they had left off the fact that they're the football captain? Yes, you would have to ask those questions. Otherwise, I mean, you can default to just counting it, but in order to exempt it, you are going to have to do a little bit of legwork on that.
So in terms of the best practice, would you suggest, if they theoretically say
Yeah, so the question was, as a best practice, would you recommend just kind of getting confirmation in writing that the athletics nexus had nothing to do with it? Yeah, I mean, if you're going to exempt it, you have to have somebody certify in writing that it was granted without regard to athletics ability. So you've got to have something in writing, and I think in that case, you're best to have both your FAR sign off on it as well as the awarding group, so that you can really truly feel at the end of the day that you've got an award that's permissible to exempt. Yes. Yeah. We are. Okay. Any questions on those? Okay, financial aid form. Quick show of hands. Who used the financial aid form this year, even though they didn't technically have to this year? Not very many. So everybody else was using squad lists. Carlin told me more of you are using it than just showed their hands. Anyway, so for the 13-14 academic year, the administrative committee did say that institutions could permissibly use either the squad list or the financial aid form. To my knowledge, no such relief will be given for the 14-15 year. So make sure you are switching things up to the financial aid form if you have traditionally used the squad list. The last week at legislation committee, the 14-15 compliance forms, including the financial aid form, were approved. So they will be posted, all of the forms will be posted, as well as the respective instructions for each of those forms to nca.org no later than July 15th. So make sure you're checking that. It'll be under the Division 2 tab of the website. Hopefully easier to find once we again get this new .org upgrade that we're supposed to be getting in the next couple of days.
What is the financial aid form? What are you referring to?
Financial aid form is, the question was, what is the financial aid form? So the financial aid form is replacing the squad list, which was the requirement previously of essentially the accounting of the aid that your student athletes are receiving. So typically filled out by in tandem by your financial aid office and probably your athletics compliance officer. Okay. Yes?
Are they going to do away with the squad list together then?
The question was, are they going to do away with the squad list altogether then? I don't know if it's going to completely I don't know that it'll completely disappear, because I think we'll still have to have the squad list function, particularly in compliance, because you need to be able to go back. So I don't believe that it will disappear. It just won't be your reporting requirement for 14, 15 and beyond.
Karen, you mentioned about when the financial aid form has to be done as compared to squad list as the date. It's by the end of the academic year, correct?
Yeah, let me check that real quick before I misspeak. Yeah, so I'll just read, the question was when the financial aid form is due. The forms shall be kept on file in the office of the athletics director, and such file shall be made available for examination at the end of the academic year. So you do have to have it to the academic year. Carlin, I don't know if you have anything to add in terms of sending them to you or not. June 15th? Okay, Carlin still wants them June 15th. That day is not changing. That day may have passed. Yes, it did. Sorry. We've all been on the road for a while. I'm losing all track of what day of the week and what day of the month it is anymore. Okay, so resources. Financial aid is an area, I will be quite honest with you, is very hard for us as an NCA staff to deal with. Because of the fact that it is so institution specific. So you all have unique scholarships, you all have unique standards. So we can certainly talk all day about what bylaw 15 says, but in terms of actual application, that gets a little bit more challenging for us because we're not in it on a day-to-day basis like you all are. So we of course do have the NCAA manual. LSDBI, for those of you that are not familiar, is our online system that has all of our bylaws. interpretations, educational documents pertaining to all of our legislation, but including financial aid. But I think the number one thing is making sure that you're communicating with colleagues, because a lot of times calling an institution in your conference or down the road is going to be a lot more fruitful than calling us as an NCA staff. We are absolutely willing to help, and I do not mean to suggest that we're not, but again, it's an in the trenches thing. So for those of you that have already looked at a particular scholarship and have some analysis of it, that's a better resource for a colleague that is looking at the same scholarship than we are at the national office. So to the extent that you all can kind of band together, makes for a happier place, to be sure. But if you do have interpretive requests, certainly submit those through RSRO, which is our online request system. I know those of you that are on campus and not in athletics may not have access to that system or even know what it is, but certainly your athletics compliance officer will know, has access to it, and can send any questions you may have through the system, and we will answer those to the best of our variability. But I do want to show just two resources that are in our manual right now and are always really helpful to us as a staff, because sometimes reading 15 pages of text gets a little mind-boggling, and you just need kind of an easy reference point. So for those of you that are familiar and working with the manual, this won't be anything new, but for those who maybe don't have a manual in your office, you might want to ask your compliance office to get you a copy of these two figures that I'm going to show you, so that you can put them up on your board next to your new path to graduation requirements. So this is truly how to determine a counter. So it's just a very easy flow chart of, did the student receive athletics aid? Yes, they're a counter. Everybody knows that one, that's easy. If they didn't receive athletics aid, but they received institutional aid, or did not receive institutional aid, non-counter. If they did, you've got to ask, do we have the proper certification? And that's going to help you determine the counter. So if all else fails, this seems really simple, but we have moments on staff where we'll see a waiver of something and an institution is panicked about, well, this is going to make this kid be a counter and this is going to do bad things for us. We need you to waive the team equivalency limit. We go to 15-1 and say, this kid hasn't triggered counter status. We don't know what you're worried about. So all else fails, go here. This next one's gonna be very tiny print. So really just the takeaway here is that it's figure 15-1. And what this does is it lists pretty much every type of award a student could get and whether or not it counts towards the individual's full. So again, student athletes cannot go over and above the full grant limit for themselves, and whether or not it counts toward the individual sport equivalency limit. So a cheat sheet. If all else fails, start here. For whatever reason, they're in the back of bylaw 15 instead of at the very beginning. I think that's just because we put all of our figures there, but to me it seems like this is an easier place to start than drudging through all the text. So if you're needing to make financial aid be a little more like English, I would certainly advise using these as resources. I've mentioned this a couple times, but I just wanted to give a quick high-level overview of this. So this time last year, legislation committee reviewed some data that was collected by our research staff that seemed to suggest the membership was really interested in deregulating financial aid. So there seemed to be strong support for a potential model that said, you know what, we're not worried about this state grant and this award and that award. All we care about is whether or not the student's receiving athletics aid and how much. Would make your jobs a heck of a lot easier, right? All you're looking at is that financial aid agreement, and that's it. So with that information, legislation committee said, hey, management council, are you supportive of us kind of taking on this bylaw 15 review to see if we can deregulate it? Management council said, sure. We know you got a ton on your plate, legislation committee, but by all means, start looking at bylaw 15. Fast forward to convention, where we had the proposal that would have deregulated academic awards considerably, and it became very clear that people were very uneasy about that. Not because they weren't thrilled of the prospect of having less work to do in terms of calculating equivalencies and tracking athletic aid, but because they didn't trust their neighbor, is what really ultimately it came down to, is that people are going to abuse this process. The rich are going to get richer, kind of a philosophy. So that proposal on the convention floor wasn't even voted on. It was referred back to the Management Council. Management Council has directed Legislation Committee to include that in the overall review. I give you that background just to say that I think at this point, and Kathy, feel free to chime in or correct me if I speak out of turn, but I don't know that we are necessarily in a spot in the Division II membership for huge sweeping change in financial aid. I think what we've really found is that it's a confusion in application kind of a thing, that it may not actually be truly broken, but how the legislation is written, how it's applied, that's what sends everybody into a tiz. So Legislation Committee last week agreed to have staff draft a rewrite of Bylaw 15, so not changing any of the legislation, but just restructuring it, putting it in plain English as much as we can, to hopefully ease the application and understanding. Now, Legislation Committee is still going to look at, does this rule still make sense? Does this still make sense? But until we have it in a format that is user-friendly to read and review, it's a lot harder to go through piece by piece and say what works and what doesn't. So a reorganization would be hopefully in effect, if approved, maybe for fall of 16. But any big sweeping proposals in terms of financial aid, we're probably not looking at until the 2017 convention. We've got to get a lot of membership feedback from both financial aid experts, like those of you in the room. We also have to have some conversations with presidents and athletic directors, the ones who are ultimately controlling the budgets, to determine how comfortable they are with any sort of change in this legislation. So again, our hope is that somewhere down the line we will accomplish the goal of making this easier for everyone and helping you all to not have panic attacks surrounding financial aid as it relates to student athletes. Because financial aid's a tough enough gig on campus just for regular students, and certainly from an athletic piece, it gets exponentially more difficult sometimes. So stay tuned on that. Like I said, Kathy is on both Legislation Committee and Management Council and is doing a great job representing all of you. Certainly, if any of you financial aid folks in the room are interested in lending your expertise and knowledge to that conversation, either let me or Kathy know. At some point, we will certainly be looping in those practitioners on campus in that conversation.